for starting late. I was on another meeting, and it just sort of dragged for a bit longer than I expected. So today we're going to start with the scope of an agent's authority. And this pretty much stems from most of our discussions about creation of agency, especially when we're talking in the context of the express creation of agency by express authority, implied authority, and apparent authority. And again, just to reiterate that giving somebody authority is the foundation of an agency relationship, because essentially agency is premised on the principle that one person allows or authorizes another person to act on his or her behalf. So it's important that we determine what is the nature of the authority that the agent has and the scope of that authority, or the circumstances in which the authority arises. And the scope of the agent's authority not only determines the legal relations of the principal and the agent in terms of their own strand of the tripod of the contractual relationship, so that there will be issues, there could potentially be issues about breach of duty and the remedies that will be dealt with later on in the course, but also the relationship between the principal and the third party, or in some exceptional circumstances, the relationship between the agent and the third party. Because if there is a conclusion that the agent had no authority to do whatever the agent might have done, as you will see shortly, there might then be personal implications for the agent. And this point has been made in quite a number of Nigerian cases. And I refer to Ashaka against Ramin Kura, which is a 2014 case. You see it. So generally speaking, as I said earlier, an agent's authority is almost invariably conferred by the same method that leads up to the formation of the agency. So if we say that there's an express agency, you will typically see the conferment of actual or express authority. If we say that the agency is one arising as a result of estoppel, for example, you will typically be talking about the conferment of apparent authority. And the principle, however, is that regardless of the type of authority conferred on the agent, the bottom line is that as much as possible, such authority must not be ambiguous. Because once there is ambiguity in the scope of authority of an agent, then the agent in all probability would avoid liability, as was held in the case of Adeosun against Afolabi. So we know already that the principal is not bound by the acts of the agent, which are done without authority or done in excess of authority. Of course, for something that is done without authority or done in excess of authority, we've talked about it in the creation of agency, that there could be the possibility of ratification. And we itemize all the elements that must be present for there to be ratification. So if an agent acts without authority on behalf of another, or he exceeds that authority and the principal does not ratify, then the agent may be personally liable under the doctrine of breach of warranty of authority. So this is one of the key reasons why we really have to understand the scope of the authority of the agent and the limits, the contours of that authority, because it has legal implications, either between the principal and the agent on the one hand, or between the agent and the third party on another hand, and lastly, as between the agent and the third party in a case where there's clear breach of warranty of authority. And the rationale is simple, which is that if you profess to act as an agent on behalf of somebody, there's an implied warranty that you have the authority to do what you say you can do or what you did. So if it turns out that you lacked that authority, you will certainly be liable to a third party who was induced to enter into a contract. Unless, and that's the qualification, unless there's a qualification, unless the third party knew or ought to have known that that agent lacked authority to bind the principal. So, I mean, so that's essentially the context of our next set of discussions. Just 1 second. Right. So what are the different types of authority of an agent? And before we start looking at these different types of authority of an agent, let me quickly tell you that as we are going along, you would see that in respect of these different types of authority, there is some measure of overlap. And that measure of overlap, you would see in one of the cases that I will refer us to, a bit of confusion on the part of the appellate courts in Nigeria in terms of conflating this different types of authority. But you will see that, I mean, one or two of them have very, very gray lines that sometimes may confuse. So please just bear it in mind and try and follow me the way that I'll try and break it down. The first one, and there are 5 of them: express authority, implied authority, usual authority, customary authority, and then apparent authority. And with express authority, that's pretty straightforward. I mean, it is the actual or real authority that is expressly and directly given by the principal to the agent under a contract between them. And as we said earlier, it may be given orally, it may be given in writing, or it may be given by deed, that is under seal, like we have in the typical power of attorney situation, either agency coupled with an interest. That is, the agent actually has an interest in the principal's property, for example, such that the agency relationship is irrevocable, but it has to be by deed, especially in respect of transactions that relate to land, as I said in the last class. And there is enough data to really explain the express authority or actual authority, like Lord Diplock said in the Freeman and Lockyer against Buckhurst Park Properties case. An actual authority is a legal relationship between the principal and agent created by a consensual agreement to which they alone are parties. Its scope is to be ascertained by applying ordinary principles of construction of contracts, including any proper implications from the express words used and the usages of trade and the course of business between the parties. This definition here captures not only express authority, it captures implied authority. And as you will see shortly, it also captures usual authority and to an extent customary authority, the statement. So if the agent's authority, for example, is contained in a deed, that instrument itself will be strictly construed in terms of the scope of authority of the agent. That document must clearly set out the precise authority that the agent has in respect of creating contractual relations between the principal and a third party. And, you know, I mean, the ordinary rules of construction would apply, whether it is a deed or it is in writing. The words in the document will be given their ordinary grammatical meaning, and you know, all the principles about paro evidence rule would also apply, and in some cases, the surrounding circumstances and the usual course of business in which the agent is concerned would also be construed in determining the true extent and scope of the authority of the agent. And you can see a dicta from the Privy Council there that the extent of an agent's authority, if in doubt, must be determined by inference from the whole circumstances. So, and I think I made the point earlier that it's always important, even though you can have an agency relationship orally, it's extremely important that the agent's authority is set out in a written document, and that authority will then be ascertained by applying the ordinary rules of construction. Hopefully, if there is no ambiguity, then all well and good. But if there is ambiguity regarding the wording of the agent's authority, then as long as the agent sort of acts in good faith and in accordance with what would be a reasonable construction of his authority, he will then be considered to have acted within his authority, whether or not he did what the principal intended that he should do. So, I mean, it's extremely important that even in setting out the express authority of an agent, there should be no ambiguity about what the agent has been mandated to do. Because ultimately, if there is ambiguity, then that ambiguity will be resolved in favor of the agent to avoid the imposition of personal liability on the agent on the grounds of breach of warranty of authority. And then in that regard, make the principal liable for what the agent had actually done. So you can see this sort of balancing act that the law is trying to do here. If the express authority is clear and unequivocal, and the agent acts beyond or outside of that authority, and the principal refuses to ratify, the agent is then exposed to personal liability to the third party in terms of breach of warranty of authority. So that's why it is extremely important that the clear remit of the agent is fully understood by the parties. Now, going on to the second type of authority of an agent. We've said that parties ideally should have express authority, or at least the principal should give express authority to the agent. But the truth of the matter in reality is that parties do not always spell out the terms that will govern the agency relationship. There is almost invariably a number of other important, how do I describe it? Other important issues within the authority of the agent that the parties may not have necessarily set out in the written document as part of the express authority. But those terms are deemed necessary to achieve the express terms. And in some cases, it may be that the parties actually did not avert their mind to it, or that the parties averted their mind to it, but consider that this is reasonably assumed, and they need not expressly state it in the contract. And for example, in the very old case of Gandhi against Pfizer, the court sort of said that a term that is not expressed in a contract will be implied if it is so necessary that had the parties averted their minds to it, they must have intended that it should be a term of the contract. So the more important thing, and this is where I want you to start focusing about the nuances between these different types of authority. So implied authority derives from express authority. It's not a standalone authority. There must first of all be express authority, and then a determination that is this implied authority necessary to achieve the express terms that have been set out. And the test is if an imaginary third party draws the parties, the principal and agent's attention to the fact that they had not said anything about a certain term. And the question will be, will the parties have said, oh, no, that's a given now. We need not to have stated it. If that term is characterized in that manner by the parties, then it means that it is an implied term in the document, or in the relationship between the principal and the agent. So implied authority takes its roots from express authority. And it depends on the nature of the express authority that will determine what are those implied terms or implied authority that goes hand in glove with the express authority. And you see shortly, as I said, some of the failures of the court to understand the nuances, So again, implied authority means that the agent has authority to do whatever is necessary for or ordinarily incidental to the effective execution of his express authority. So, for example, if an agent is appointed to conduct a particular trade or business, to sell somebody's car, for example, and the express authority does not say that, oh, the agent should collect the money and pay it into his account and then transfer it to the principal. Of course, that is necessarily incidental to his telling the car that he must collect the money and retire to the principal. Same thing too with an agent employed to sell certain properties. The authority, just like with the car property, there is implied authority to describe the property, to give full and accurate information about the property, and not lie about defects in the property or anything of that sort that could create potential legal liability to the principal, as was stated in all those old cases in Mullens and Miller and Ryan and Pilkington. But I then refer us to a case, a Nigerian case, the Salbody Group Limited against Doing Investments. It's a very recent case, just 2 years ago. And the Court of Appeal, in that case, relying on another Court of Appeal decision, said this: agency relationship can in law even be implied, which is okay, and is referred to as the implied authority or apparent or ostensible authority of an agent acting within the scope of the authority vested on him by the principal. Note that, but let's continue. And then reference is made to an earlier case where the court had explained this concept of implied authority so succinctly, as meaning that implied authority is also referred to as apparent or ostensible authority. It is the authority of an agent as it appears to others. Under the doctrine of apparent authority, the principal may be bound to third parties because the agent appear to have that authority. Though the principal and agents, the principal might not have given such authority. Let me just tell you that, with all due respect, this is not accurate, because you can see that in this Salbody case, the Court of Appeal is conflating implied agency and apparent, implied authority and apparent or ostensible authority as one and the same thing. And they are not one and the same thing. And you will see it very shortly. At least we've spoken about implied authority. That one, implied authority stems from express authority. Before you can even start considering implied authority as a concept, there must have been express authority. So if there is no express authority, you can't be talking about implied authority. That is number one. Number two is that implied authority is that authority that is crucial to the implementation of express authority. It is ordinarily necessary to have that implied authority read into the express authority of the agent. So please bear that in mind in terms of the meaning of implied authority. And you will then see, when we talk about ostensible and apparent authority, whether this characterization by the Court of Appeal in these two cases is actually accurate or a bit of a misconception. Even though you know that I said at the beginning that the contours of these different types of authority, they mesh together sometimes, but certainly not in the context of implied authority and ostensible or apparent authority. You can see them meshing together in the context of usual authority and customary authority, and we'll talk about it shortly, but certainly not in this glaring manner of conflating implied authority and apparent or ostensible authority as one and the same thing. But In the case of Rosenji against Bakari, which is an old Supreme Court case, and the Supreme Court was in that case talking about the implied authority of an agent. This is this is a proper way of explaining it. First of all, it should be realized that the agent need not be authorized in writing. We've established that. And indeed, the name and identity of the principal on whose behalf the agent acts need not be disclosed. That we'll talk about later. But it is the duty of the court in all cases to study the memorandum referred to and then to draw the correct inferences from its contents. And then in talking about implied authority, and it says, but such an authority may be conferred upon an agent expressly or may be inferred from the circumstances of the case. So it's just important that we understand the narrow remit or the narrow circumstances in which implied authority can arise beyond express authority. Okay? So, usual authority. And like I said, this is where usual authority and, as we shall see shortly, customary authority, where I admit that there's a bit of overlap, but one tries to just explain how it works. In the case of usual authority, it will typically arise where the agent is a professional and has now been appointed to act on behalf of somebody. And you know that professionals, either an estate agent, a quantity surveyor, and stuff, they have the rules of their own profession and trade and customs that are peculiar to that professional calling. So when acting as an agent in that circumstance, it is not uncommon for the parties not to expressly set out all the terms governing the agency relationship. And in such circumstances, because the agent is employed as a professional, the principal must be allowed to assume that the agent would act in accordance with the express terms, but also within the ambit of the rules of profession, of the profession and customs of the trade of that agent. So unless the principal does not want that, then he must expressly exclude those usual authorities of the agent, which will be unlikely because for him to employ a professional as an agent is because of that person's professional calling that he has employed him as an agent. And so in that context, the agent is then authorized to do what is usual in his trade and profession for the purposes of carrying out his authority or anything that is necessary or incidental thereto. So, for example, the old case of Reed and Anderson, you know, a commission agent was employed to make a bet for his principal. It meant that he was also impliedly authorized to pay the bet if he lost. Just like if he had won the bet, he would have collected it and remitted it to the principal. So please bear in mind this point about usual authority. Usual authority in the context of a professional agent who has rules, trade, and custom of that profession to guide him in the performance of his duties as an agent to the principal. And even if those terms are not expressly set out by the principal, it is assumed that the principal recognizes that that agent would comply as part of the exercise of authority with the rules of the profession. Just like if you also appoint a lawyer to do something, lawyers are bound by rules of professional conduct in the way and manner in which they should act to do certain things. And the principal in such circumstances will be liable for the acts of the agent where he was acting in accordance with the rule of his profession. Unless, as I said earlier, he has been prohibited or restricted from acting in the way that he has done, and the third party has notice of that restriction. So you can see two important elements that can trump a question as to usual authority of an agent. One is that there must have been express prohibition by the principal precluding the agent from acting in accordance with the rules of his profession. And I dare say that such circumstances will be rare because any professional worth his salt who has been employed to act as an agent will be extremely wary when the principal says that, oh, there are certain rules of your profession that I don't want you to apply in the context of this relationship. It's just counterintuitive, but at least in theory, let us even assume that it happens. That is fine. The first thing is the preclusion. And the second point is the knowledge of the third party regarding that restriction. Because, as was stated in Watau against Fenwick, and Watau against Fenwick is a very popular case in the context of law of agencies. Quite a number of principles evolved from that case. So, I mean, if you have the time, have a look at Watau and Fenwick. And essentially, what the court were saying is that if a person employs another as an agent in a character that involves a particular authority, just like we said, rules, customs, and trade that guide that particular profession, he cannot, by secret reservation, deprive him of that authority. So that is the reason why there is that second element that the principal, the third party must also be aware of that restriction on the authority of on the usual authority of the agent. In the absence of that, then the agent would not be personally liable for breach of warranty of authority, and the principal would be bound by what the agent has done on behalf of the principal. Now, the next one is customary authority. And this is where I say, you know, the nuance between customary authority and usual authority might not be entirely clear, but let's have a go at it. Now, in the case of customary authority, which is the distinction with usual authority, in the case of customary authority, we have an agent who is appointed or employed to act for the principal in a certain place or market or business. So unlike usual authority, which focuses on the profession, customary authority focuses on the agent acting in a certain place or market. And in that situation, the agent is impliedly authorized to act according to the usages and customs of such place and market. So if you appoint an agent to act for you in Alaba market, if there are certain usages, there are certain customs peculiar to Alaba market, then that agent has the customary authority to do those things. Now, the trade, the customs applicable to Alaba markets might be totally different from the customs applicable in Ladipo market or in Mile 12 market. Okay, so an agent acting in Alaba market cannot say that, oh, but it is usual for me to do this kind of thing because that's the way that they do it in Ladipo. Okay, so even though you can see that customary authority too is like of a similar species to usual authority. But as I said, the difference between the two is that in the case of usual authority, an inference is from the ordinary course of a particular trade or profession. But in the case of customary authority, it is all about the custom and practice of a particular place or market. And so you can see what Park B said in Bailiff against Butterworth. If there is said at a particular place and established usage in the manner of dealing and making contracts, a person who is employed to deal or make a contract there has an implied authority to act in the usual way. And, even though they use the language of implied authority to act in the usual way, the focus in the context of customary authority is the custom and practice in the particular place or market where that person is acting as an agent. And once that person acts in accordance with such market practice, even without express authority, the principal would be bound because the expectation is that that express authority that was given to act in that market also includes the customary authority that somebody ordinarily has in the performance of that function for which the agent has been employed. So you can see that even though we're trying to separate implied, usual, and customary, but they are variants of a similar theme in the sense that they all speak to the authority that an agent has that is not expressly given, but would be implied because it is usual in that profession or it is customary in that place. So that's the way that I would characterize it in an easy way for you to understand that there might be intersections between these different forms of authority, but at least we've tried to sort of emphasize how they are different, even though there are variations of the same thing about an implied contract. But the principal can only be bound where the custom is known to him or where the custom is so notorious that the principal can simply not be heard to say that he had no knowledge of it. and that custom must be reasonable and lawful. And if while lawful, it is not a reasonable custom, then the principal will not be bound by it unless he expressly consents to be bound by it. And all those cases there sort of establish that point about the reasonableness and lawfulness of the custom, and also makes a distinction between where it is lawful but unreasonable. The principal could still potentially avoid liability unless it is shown that the principal expressly consented to be bound by that custom. So again, just to recap, we see how these strands of authority evolve. Express authority in black and white. You can do A, B, C, D for me. Principal states that to the agent. Now, but in reality, even though they stated A, B, C, D, there might be E and F, which they have not expressly stated. But if you had asked both the principal and the agent, but you didn't state E and F, and they'll say, oh, but that is a given. We need not state E and F. That's E and F would be within the implied authority of the agent. So that if he does E and F, as well as part of his compliance with A, B, C, D, the principal would be bound to the third party. There will be no issue about the agent acting beyond the scope of his authority. But if the E and F had been asked and they say, no, those ones are not a given. I don't really think that those should be part of the express authority. You can see that E and F cannot be implied within the context of express authority. And then when you move a bit further from that, and then the agent in this case is not just an ordinary agent. It's just not an anybody that has been contracted to do anything. This person has a professional calling. And part of the reason why the principal has appointed this agent is because of that professional calling. Now, the rules, the customs that are peculiar to that professional calling would be usual authority that the agent can also exercise in addition to the A, B, C, D express authority that has been given to him. Because in all probability, the parties are not even ready to go and extract all those usual things that the agent of a professional with a professional calling would do and put it in the agreement. It might make the agreement unwieldy. So all these things will be usual and will come within the usual authority of the agent. And then finally, you have a situation where the agent was employed to do something from the principal in a particular place or market. Again, the market dynamics, the customs, the trade customs in that market would be part of the customary authority of the agent in acting on behalf of the principal, in addition to the express authority that has been given to that agent. Now, lastly, we have apparent authority. And remember the Doing investment case, and I said to you that in that case, I feel that the Court of Appeal has conflated implied authority and apparent authority. And I will try to demonstrate why I make that suggestion. You know, when we talk about an agent's apparent or ostensible authority, this is the authority which the principal, by his words or conduct, has led third parties acting as reasonable and prudent person to justifiably believe was conferred on the agent principal. So again, the issue about apparent and ostensible authority is premised on the principle of estoppel. The conduct and the words of the agent, which have been made to a third party. And a third party, in the sense of a representation to the third party. And the third party has relied on that conduct or the word of the principal. So, where one person expressly or impliedly represents to another to have authority to act on his behalf, and the third party reasonably believes him to possess that authority, and then deals with that person in reliance on the representation made, the principal would be bound to the same extent as if actuals of the principle of estoppel. Because the principal would then be stopped from denying that ostensible authority. Ostensible authority, the authority that is seemingly apparent from the conduct of the principal, from the work of the principal, from the words of the principal, from the had suggested to the third party that that person has the principal's authority to act in that. Sorry, guys, can you hear me now?
Yes, sir, we can hear you. Yes, sir.
Okay, sorry about my connection. And unfortunately, I can no longer share my slides, but we'll just continue anyway. Um, um, so the Supreme Court essentially said in Olowofoyeko's case that an agent is regarded as having apparent or ostensible authority where the doctrine of estoppel operates to give rise to the agency relationship or to create some, if not all, of the effects of that relationship. The agent's authority is the product of the principal's conduct. His representation that the agent has been authorized to act on his behalf. It is an authority which apparently exists, having regard to the conduct of the parties. So you can see that in the context of apparent or ostensible authority, it is focused more on the conduct of the principal that creates an estoppel in preventing him from arguing otherwise than that the agent had the authority to do what he did. So you can see that this is different from implied authority, as the Court of Appeal seems to be suggesting in the doing investment case. So it's important for us to understand the basis of apparent authority. And the Supreme Court has said it clearly and rightly in this Olowofoyekun's case. It is the conduct, particularly that of the principal, that raises the ostensible and apparent authority point of an agent. And again, if you look at Eagle Site Limited against
sir,
yes,
we can't see your slide, sir.
I just told you that I've not been able to share the slides anymore because Dr. Labinton has left, and I'm no longer co-host because I got out and came back in. So we'll just continue. I think I
Sir,
made
you can correct. You are a host currently.
Okay, let me see whether I can still share now. Oh, okay. Okay, so we're back. Good. So another case there, Eagle Site against Rothbams. And again, see what Justice Peter Affen says on this point about apparent or ostensible authority. And I really like this quote from Peter Affen, JCA, where a person by his words or conduct represents to a third party. So there must be words or conduct which amount to a representation to a third party, that another has authority to act on his behalf. He may be bound by the acts of that order or other, as if he had in fact authorized them expressly. This doctrine, called the doctrine of apparent or ostensible authority, applies to cases where a person allows another who is not his agent at all to appear as his agent. To cases where a principal allows his agent to appear to have more authority than he actually has. To cases where a principal makes reservation in his agent's authority that limits the authority which such agents would normally have, but fails to inform the third party of this. And to cases where a principal allows it to appear that an agent has authority when such authority has in fact been terminated. And it then says the doctrine is said to be an application of the estoppel principle, but it is a somewhat vague one. Admittedly, the normal rules being leniently applied, perhaps as regards reliance on the representation, and it might be better attributed to the normal principles of objective interpretation of contracts. So at least from this sort of way that Affen JCA has captured this point in the Eagle Site case, you can see all the elements, like all those elements, and we have talked about them in creation of agency by estoppel. So it's still the same thing in the context of the authority of an agent that has been created by estoppel. There must have been words or conduct which constitutes a representation to a third party in such a way that a third party has relied on it, and there's been detrimental reliance, and the principal is then stopped from denying the fact that the person is the principal's agent. I can see somebody raising their hand. Yes.
Thank you, sir. Okay, so I would, sir, can you hear me?
Yes.
Okay, thank you. Sir, I wanted to ask what the main distinguishing factor between implied authority and apparent authority is, because I seem to find more similarities. I can, from what you explained, I can see the similarities, but to help me understand better, what is like the main distinguishing factor between implied authority and apparent authority?
Okay. I'll take it again. Implied authority takes its roots and its life from express authority. If there is no express authority that agent has the authority to do A, B, C, D, E and F, which are necessary terms for the agent to perform the authority A, B, C, D, will not be implied unless there is that express authority. So implied authority stems from express authority and is extremely important that they be implied, because if the parties had adverted their minds to it, they will say, oh no, that is a given. We don't need to put it in. That is standard. It makes sense. But apparent authority is different. Apparent authority focuses more on the conduct. There has been no express authority, really. But the conduct of the principal is such that, can people go on mute, please? There are people disturbing this class.
I suppose I know Jamie for road. No, I'm going to find the food. You don't dey para.
Who is here, Aspire or something? Can you please go on mute?
Yes. Yes.
Aspire or something.
Epsiba, please mute your mic.
Come on.
Is it like that? No. Normal. I told her that.
Anyway, I've muted the person. So apparent or ostensible authority focuses on words spoken, conduct, which is suggestive of an agency relationship, and a third party then relies on that representation to their detriment, and then the principal is stopped from denying that there was an agency relationship in the first place. You know that it cannot deny in the case where there's an express authority, and then there are some terms that are necessary for the implementation of the express authority that are then categorized as implied authority that the agent has in addition to the express authority. So that's the distinction between implied authority and express authority. I see that there's some other hands raised up.
Thank you very much, sir.
Okay. So please drop your hand.
Yeah. So are you trying to say that the conduct is what distinguishes implied authority from the apparent authority? Does that mean that there is no conduct in implied authority, but just in apparent authority? And
yeah,
by
that's
conduct,
the point.
What do you mean by conduct exactly?
Conduct, how you act, how you behave, things that you say, you know. Somebody, an agent who doesn't have your express authority is saying to the third party to your hearing that, oh, I have the principal's authority to do X, Y, Z, and the principal did not say anything. By his conduct, he has given the impression that truly there is that authority. He cannot now come around later and say, hey, this guy is a joker, and you believed him. Why would you believe him? You know that he's a known liar. So why would you believe him? Such a thing, that is conduct that he'll be stopped from denying. So conduct is just all about circumstances, body language, words spoken, and stuff like that.
Thank you very much. I understand now.
Yeah. I see a hand raised by an Isaiah. I don't know whether that a mistake or what.
Good afternoon, sir.
Good afternoon.
So, through your analogy, you said that an agent who has express authority can do A, B, C, D, or he needs an implied authority to do it, right?
Yeah, go on.
That means an agent can have both express authority and implied authority, right?
Of course. Of course, that's the point.
Okay, sir. Thank you, sir.
That's the point. Implied authority cannot stand alone. Implied authority cannot exist alone. That's why I kept saying that implied authority derives its roots and its life from express authority. Deborah James.
Good afternoon, sir.
Good afternoon.
I just want to ask if you could get your slides on creation of agency and today's own as well.
Yes, I'm sure I'll send it through once we are done.
Okay, thank you, sir.
Yeah, you're welcome. So let's just quickly round this up. We've talked about this when we were dealing with creation in terms of those important elements about estoppel, representation, reliance, alteration of position to the detriment of the third party. So those ones are very clear. And on the point about representation, it must have been made by or with the authority of the principal. So ostensible authority cannot be created by representation of the agent himself. So for example, the instance that I gave now, the turning point wasn't what the agent said to the third party that, oh, I have the authority of the principal, but that the fact that the principal was there to his hearing and he was just smiling and he was just laughing. And he didn't say, no, I don't, you don't have my authority. So it is that conduct of the principal that triggers the ostensible authority to act. So you can see Amagas against Mondogas, where the English Court of Appeal clearly stated that the representation must come from the principal. There can only be ostensible authority if the person asserting it can show that the supposed principal held that person out. And you see that ostensible authority is different from actual authority, as I've said before. I can see some hands again. I can see Adeshina, Kende.
Okay, sir. Good morning, sir.
Good morning. Good afternoon.
Yeah, my question, yes, good afternoon. My question is that when customary authority conflicts with usual authority, how is it resolved?
How do you mean? It's highly unlikely that customary authority and usual authority would conflict. Because as we said, usual authority speaks more to the practices and custom of a profession, as distinct from customary authority that speaks to trade and customs of a place or market. Maybe there might be instances in which a professional is also acting in a particular market. So in that case, it's even more protective of the agent, because it will have the usual authority to act in accordance with his profession, and it will also have the customary authority of acting in that particular place where he has been contracted to act as an agent. So rather than there being a conflict between usual and customary authority, I can see a situation where the authority of the agent can be expanded where he is a professional that acts in a particular market that also has trades and customs that is entitled to also apply. Does that answer your question?
Yes, sir. Okay, sir.
Thank you. So you've seen the slides when it's given to you instances of the flow of representation. The Lloyd against Grace Smith, I think is a popular case that you guys will have done in heard about in contract as well. And the words or conduct must convey a clear, unambiguous message that the agent has the authority to act. So again, just to reemphasize, and the distinctions in some of the cases, ostensible authority is seldom applicable where a person has never at any time had authority to contract. So ostensible authority is more likely to apply where the agent either goes beyond the limits and the conduct of the principal is such that even when he went beyond that limit, he allowed it and didn't say anything against it. And remember that, and it's also different from a situation where the agent goes beyond authority. The agent is, the principal is fully aware and ratifies it. Okay, and there's no issue anymore about the scope of authority. But so, I mean, if somebody, an employer, for example, as I put in the slide, allows his employee to habitually purchase goods for him on credit from X. So X, the third party, has become accustomed to looking to the principal for payment of anything that the agent comes to buy from him. The principal cannot then privately revoke his employee's authority without giving that third party knowledge that the so-called ostensible authority has been terminated. I see another hand. I can share or something. I can share.
Good afternoon, sir.
Good afternoon.
Yes, sir. So you mentioned that implied
Authority.
implied is something, yeah, authority.
I don't know whether it's only me, but I can't hear you. Can anybody hear him?
Authority, like a limitation when.
No, sir, we can't.
Yes, I can hear you. Can you hear me, sir?
No, we couldn't. I didn't hear your question at all. You are just breaking up.
Okay, is it clear now, sir?
Yes.
Is it better?
Yes. Yes.
Okay, so I said, can I ask whether implied authority is subject to express authority, since it is subjected to express authority? Whether there's a limitation.
I think I answered the question like 2 minutes ago that exactly implied authority derives its life, its roots from express authority.
Yes, I'm referring to limitations.
Sorry?
Whether it is limited. Implied authority, whether it is limited.
Oh, it is limited. You can't, and the limitation on implied authority is the question that would have been asked of the principal and agent, that the authority to do E and F, why didn't you put it? And they will say, oh no, E and F are given. We need not have put it in expressly in A, B, C, D, because it is taken for a given, because E and F are so crucial to the agent performing the authority A, B, C, D that I've given him. So you can't have any authority at large. And that is why implied authority is tied to the express authority that is given in any particular circumstance. The implied authority that would be given by, and it depends on the principle, so I don't even want to use any analogy and confuse you. What you decide as principal to expressly confer as authority to your agent, and you set it out, might be different from what I will set out as the authority that I want to give my agent. And the implied authority that would arise in your own scenario can be totally different from the implied authority that would arise from my own scenario. And in some cases, it may be the same, but there is no hard and fast rule, because what is looked at is the scope of the express authority. And what are those incidental things that are needed by the agent to do those things that have been expressly conferred on him would be what would are within the scope of implied authority. So just to address your point, implied authority cannot be at large. It is focused, it is narrowed down to what has been set out expressly that can be done. And what are those things that are necessarily crucial, but are not expressly stated? Because more often than not, the parties cannot state almost everything under the sun. But those implied authority points or terms must be necessary to the implementation and conduct of the expressly stated terms of authority. Eyo Benita.
Good afternoon, sir.
Good afternoon.
Yes, sir. Could you please further explain the concept of holding out?
Yes, that was where I was going to.
All right, sir.
So essentially, just like the analogy that I gave, where the agent is faffing around with the third party, giving the impression that he has the authority to act as an agent, and the principal is there and did not pull back that impression, but rather encouraged the impression. That is the conduct of holding out. And when it is said or can be said that the principal is holding out in that, it's part of this representation point, then he's stopped from denying that the authority does not exist. So the conduct that gives the impression of an agent having authority is what is characterized as holding out. You know, same thing with the husband and the wife scenario in the agency of necessity, holding her out as an agent to contract on his behalf. So holding out is essentially about the conduct that gives the impression of an agency relationship. So I give other instances of apparent authority in situations in which it may arise based on standard practices of a trade, or the principal entrusting certain property or documents therein to an agent, or from the appointment or placement of the agent to a position that carries with it the implication of authority. There's also the issue about similar facts or similar acts. If somebody had done something like that before and there was no question about it, no issue about the scope of authority, and he does it again, it's more likely to be considered to be part of the apparent authority. And again, we've said this again and again, for there to be a recognition of ostensible or apparent authority, there must have been reliance. there must have been reliance on the representation given to the third party that the agent has authority to act. Representation might be by words or by conduct, but that representation must be the proximate cause, that is the trigger that leads that party, the third party, into believing that the agent has authority. And lastly, there will be no ostensible authority where the principal has held the agent out, which the third party relied on, but has not suffered any detriment or alteration of his position as a result of such reliance on the representation. And of course, anything to do with estoppel, we keep saying it, there must be detrimental reliance. That is, the reliance must have led the person to do something that they would ordinarily not have done. And as a result, they suffered some kind of impediment, some kind of loss, or what have you. Okay. And any questions? That would be all. We have only 2 minutes left.
Please, sir, can you explain the alteration of position again?
So alteration of position simply means when we're talking about the issue of authority and whether somebody has or hasn't got authority, and more importantly, the implications, because if we say somebody has authority, it means that the principal cannot avoid a liability to the third party. The situation in which this point is relevant is that somebody has purported to act on behalf of the principal. The third party entered into that contract with that agent, and there has been a breach or there has been a loss. Somebody has suffered damage. And then the question will now be, is it the principal that is going to be liable? Or is it the agent who is going to be liable on the basis of the principle of breach of warranty of authority? And all these questions about the different strands of authority is what will lead to the conclusion whether the principal is bound or not. So there would have been detrimental reliance. The question would only arise when there's detrimental reliance and the third party wants to sue somebody. And the question would be, who should the third party sue? Is it the principal on the basis that the agent acted within his express authority, or the agent acted within implied authority that is tied to express authority, or that the agent acted on the basis of usual authority by virtue of his professional calling, or the agent acted on the basis of customary authority because of the trades and customs that relates to the place or market where the agent was supposed to operate, or as a result of the representation by the principal, which was relied on by the third party in entering into that contract with the agent. Bolaji.
Okay, sir.
Okay,
Good
thank you, sir.
afternoon. Yes, so I wanted to ask, so sir, when you were showing the connections between all the forms of authority, you said that implied authority can be seen in instances where authority is inferred from maybe trade practices or market practices. But I also ask if there are other forms of implied authorities apart from this that have been mentioned, sir.
I'm not quite sure that I get your question, because and just to address the point I made earlier, that there is no what I'll call general implied authority. Implied authority would be dependent on the particular circumstances of each case. and the scope of the express authority that has been given to the agent. And I think that is what you need to focus on, is that implied authority is not a general authority that is known. It can only be determined upon a construction of the express authority and upon a consideration of the fact that if the parties had adverted their minds to it, they would have put it as express authority. Or they could feel that it is so trite that they need not have put it in the express authority, because those instances, that authority is crucial to the agent being able to perform the express authority. And I use the illustration that a principal agency relationship between myself and somebody else in terms of doing something for me, in terms of selling a property for me, might be different from Mr. X also engaging Mr. Y to sell his own property, because number one, the nature of the properties are different. Mine might be a commercial property that has slightly different considerations in terms of the way and manner in which it can be sold. And the other person might just be a block of flats in a building of 100 flats, which might also involve slightly different things. So the implied authority in my own case would or could be different from the implied authority of that other case. So implied authority is not a general thing that applies in every situation. Implied authority is dependent on the nature of the express authority that is given in any particular circumstance. Okay. Thank you very much, everybody. Have a good afternoon. I think that I'm done. I'll let you know. But in any event, I'm sure that whoever is taking up next time would be in class on Friday. Thank you very much. Good afternoon.